Hello, everyone, and welcome to the session. My name is Leke Kende. I'm a partner at Kende & Partners, a multidisciplinary law firm based in Abuja, and I will be moderating this session titled Operators of the Justice System. Studies suggest that justice administration affects poverty and economic growth. Countries with efficient justice systems have lesser poverty rates and better economic indices than countries with inefficient justice systems. A more effective judiciary may also contribute to reducing violence and corruption by creating a deterrent effect on criminal acts and increasing citizens' trust in the quality of institutions. As a result, everyone ought to be interested in the administration of justice and the roles the operators of the justice system play. During the next hour, we shall be exploring the future of Nigeria's justice system from the point of view of operators of the justice system with some distinguished members of the legal profession in Nigeria. The first member of the panel is Chief Sebastine Hon. Chief Hon is a senior advocate of Nigeria and one of Nigeria's foremost constitutional lawyers. He is the principal partner of Law Shield Partners, a law firm in Nigeria with offices in Abuja, Port Harcourt, and Makurdi. The second panelist is Mr. Mazi Afam Osigwe. Mr. Mazi Afam Osigwe is a senior advocate of Nigeria and senior partner at Law Fort, a full-service law firm located in the heart of Nigeria's Federal Capital Territory. Mr. Afam Osigwe is also the former General Secretary of the Nigerian Bar Association. The third panelist is Mrs. Chioma Onyenucheya-Uko, a lawyer, mediator, arbitrator, and gender rights advocate. She is the principal legal consultant at Zest Legal Consults, a law firm based in Abuja. Last but not least is Dr. Sirajo Yakubu. Dr. Sirajo Yakubu is a legal practitioner and academic. He is the principal partner at Sirajo Yakubu & Co. and is also the head of Department of Public and International Law at Now University, Abuja. A warm welcome to all the panelists. I'm glad you're here to join in this important discussion. Before going into the discussion segment, I shall invite each panelist to give a brief opening statement. At this point, I would like to invite Chief Sebastine Hon, Senior Advocate of Nigeria, for his opening statement.
You're welcome all. Thank you for this opportunity to discuss Nigeria's judiciary at an international level. As a matter of fact, our judiciary has come to stay. It has come a long way with challenges, with the ups and downs, and all whatnot. Now, discussions on a topic like this involve both a consideration of relevant constitutional provisions, the rules drafted by the National Judicial Council and the Federal Judicial Council. And then maybe as we go, depending on the time and the angles, issues are coming up, we shall also be trying to do maybe a comparative analysis or insight into some other, into what happens in other jurisdictions. So it is actually a good topic and then taking place at a most auspicious time because the Nigerian judiciary is undergoing some serious challenges, especially we're all witnesses to the fact that 14 Supreme Court justices wrote to the Chief Justice of Nigeria, a stinker, and that happened for the first time in the history of this country, forcing the Chief Justice of Nigeria to resign. And personally, I have been fighting for the improvements or for improvements in the lots of the justices and the judges of the Nigerian judiciary. And very recently, just about 1 week ago or thereabout, has secured a landmark judgment at the National Industrial Court to have their wages and emoluments upped or increased. So personally, I have been involved and I'm very glad to be here. I will just do my best within the time frame. Thank you.
Thank you, Chief Hon. May I invite Mr. Mazi Osigwe, Senior Advocate of Nigeria, for his opening statement.
Thank you so very much, Mr. Kennedy. I think the discussion concerning the Nigerian judiciary is one we'll never get tired of until the issues that are on the front burner are addressed. And such issues are issues of remuneration, autonomy of the judiciary, the issue of corruption, issue of judicial appointments and discipline of judicial officers, issue of succession in the judiciary, whether the need to continue to retain the current seniority situation in the judiciary where the most senior judge becomes the chief judge or the chief justice of Nigeria, or should the political leader, the president of a country or governor of a state, be allowed to pick a person to be so appointed, since there is no such restriction on their power by the constitution. But we need to address some of these issues because, as we say here, the judiciary is the last hope of the common man. And if, as happened recently, 14 justices wrote a skill petition against Chief Justice, questioning his integrity, questioning his ability to do the work, and a whole lot of issues, then we need to address these issues. Otherwise, the public will lose the confidence in the ability of the court to dispense justice. In any case, it's arguable whether they haven't lost confidence in the judiciary, because many people believe that if you have money, then you can have your way in the court. And if you don't have money, you may not be able to make justice in the court. And there are some of the views that most of our courts render judgments without rendering justice in cases before them. So I'm very glad to be part of this discussion. And I'm sure that I'll be able to share my thoughts and also learn from other panelists who would also have share their thoughts about the judiciary in Nigeria.
Thank you, Mr. Osigwe. May I invite Mrs. Chioma Onyenucheya-Uko for her opening statement?
Thank you very much for the opportunity to be part of this august panel. And my respects to all the speakers who have spoken ahead of me. And I think for me, I want to say that it is important that in looking at the justice system, the whole spectrum of it, that we factor in the important roles played by the non-judicial staff. And this is important because while most of the conversation and most of the focus has been on the judicial officers as custodians who dispense justice in our courts, the support staff, who are the non-judicial officers, are integral to the dispensation of justice, because lapses that occur in the services they offer and in the support they give to the judicial officers are critical to effective delivery of justice. And of course, if we look at the whole spectrum of the judicial system, including the law enforcement and the corrections, of course, the courts being the focus for this conversation, you can tell that for the public, who are the consumers of the services that the courts render, and most of them do not get to interface with the judicial officers, especially at first instance. And the impression that they get from the attitude and the service that the non-judicial officers deliver affects greatly the perception of the public of the judiciary, which in turn determines the confidence of the public in the judiciary or otherwise. So any conversation that happens without serious focus on the fate, the remuneration, the appointment, the training of non-judicial officers would be a conversation that is missing a critical link that impacts greatly on the outcome of the service sector delivery. So I think I'll rest it for here until the questions come, and then I'll take it further. Thank you very much.
Thank you, Chioma. May I invite Dr. Yakubu for his opening statement?
Thank you very much, Kendi. I'm invited, to speak in my opening remarks on the legal training and education in Nigeria. Legal training and education is very important. Very important is in the sense that a whole arm of government is actually manned by those who acquire legal education and training. Only those who are lawyers can be found in the judiciary in an active role. The others who are there mainly are the supporting staff. So the importance of legal education and training cannot be overemphasized at this stage. If we have a whole arm of government with a lot of powers to decide on matters before it between parties, either as in a civil suit or in criminal matters, then you can see that legal education and training is very important. And because it is very important, then the way lawyers are trained should be looked into critically. At the moment, in most of our tertiary institutions, what we are having is the top-down directive approach in terms of teaching law students. Rather, because the top-down directive approach does not give room for interaction, does not give room for the students themselves to lead their learning process. There's need for to shift from this top-down directive approach to facilitation. Facilitation will allow the students to collaborate. They will allow the students to share knowledge. It will allow the students to explore, and then it will allow them to test the practical aspect of the law profession, because as we rightly know that law profession is practice-based. It is either a client coming to give you briefs and take down the briefs. They don't know, they only know that they have the problem, but you are the one to take them out of if it's a problem, you are the one to take them out of it. If it is a business that they want to do, you are the one to guide them properly. Even politics, law plays a greater role in determining what should be done and what needs to be done. And even after, during election, when it comes to politics, in the pre-election matters and even post-election matters, a lot of input from lawyers are required. Then the whole justice system, the whole judiciary is involved. So training students who become lawyers and who populate the judiciary and who drive the justice system in Nigeria is very, very important. Then what else after becoming a lawyer? Then there's need for continuous education. Lifelong education is the answer here. A lawyer must continue to develop himself so that he will stay, he will keep himself abreast with the current laws and with the current happenings and practice the world over. Then the role of technology in education, in educating the students. With COVID-19 pandemic, we can see that a lot of institutions have embraced, virtual teaching in order to continue imparting knowledge to students. And in fact, with the advent of what we call now the metaverse, we should, it's highly probable that one day we will be sitting in our homes and we'll be conducting court sessions as if we are a real court while we are just not out there. So I think to wrap up, the future of the Nigerian justice system depends on the training of the quality. It depends on those who operate it, and of course, the standards of those who operate it depends on the quality of training they receive from the university up to the law school. With this, I think I'll stop, and I'll be glad to answer questions. Thank you.
Thank you, Dr. Yakubu. At this point, we shall be heading straight into the discussion segment. I would like to remind our audience that they can send in their questions, and if we have enough time at the end of the discussions, I will put some of those questions to the panelists. So let's dive in. Chief Sebastine Hon, this question is for you. Constitutionally, a lawyer who meets the requisite post-call experience and the requisite constitutional requirements can be appointed as a justice of the Court of Appeal of the Supreme Court. However, in recent years, the practice has always been to appoint only serving members of the bench to these positions. Now, several stakeholders have called for the widening of the recruitment pool to include academics as sir, in your opinion, are there any advantages of appointing practicing lawyers and academics as justices of the Court of Appeal and the Supreme Court? Or is the current model of recruiting judicial officers to these positions adequate?
Well, I will have a yes and no answer. The yes answer is that for practitioners, legal practitioners who have distinguished themselves, who have also met the constitutional threshold in terms of the number of years, they should be appointed. The clamor for this has been there for a very long time. And I believe that what any justice of the Court of Appeal can do, or of the Supreme Court can do, a good lawyer who has been practicing for between 12 and 15 years as per out to the Constitution, and who has been focused, well-focused, and also who has been very busy in diverse areas of the law, can practice, can become a justice of the Court of Appeal or the Supreme Court. Now, this clamor has been on for some time. This is not just the first time. And I think that we came very close to this thing happening in the last two appointments at the Supreme Court. But somehow it couldn't be. The body of senior advocates of Nigeria proposed some names, and one of the names is one of our foremost lawyers, Idigbe, Chief Idigbe, who was also in the first segment of this webinar. I wouldn't know why he wasn't considered, but this is a personality that has practiced law in all the strata of courts and who also has good experience, and a lot of other lawyers in Nigeria who have such experience. It will add so much value to the bench. And what are the reasons for this? What are the additional reasons for this? If you don't do that, then the justices of the Supreme Court who are aiming, or the justices of the High Court, or the Customary Court of Appeal, or the Sharia Court of Appeal, who are aiming to be promoted to the next higher court, will be lackadaisical and will relax. They will just consider themselves that, well, after spending so number of years on the bench, they will look at my number of years and then promote me. In other words, it is now looked at as if it's a civil service issue, whereas we're supposed to have the best in our appellate system. So that is one advantage. The other advantage is that you are bringing fresh blood, so to speak, to mix with the people who are already there. So let's put it very hypothetically, you are bringing people from outside, quote and unquote, and then mixing them with people on the bench who are people who are inside. So you have that natural blend, the word outlook, then the inner circle outlook, if you like it that way. So they will blend, and then they will give us the best. And then you also, the third reason is that you will also be bringing dynamism into the system. We have had experiences whereby, for instance, Honorable Justice Nnamani of blessed memory was elevated as Attorney General from outside, and he became one of the best jurists ever. Honorable Justice Oputa came straight from the High Court. He jumped to the Court of Appeal, and he also performed so well on the bench. Then, in rare cases, Professor Nicky Toby came from the academia, and he also did well. So that was why I said it was a yes and no answer, because people in the academia, I'm not being contemptuous of what they are doing, or I'm not denigrating what they are doing. But on a very serious note, very honest note as well, practice of the law is slightly different from what happens in the academia. So when you come on board, especially at the appellate level, and you have not had any experience as a practitioner, even some little nitty-gritty will worry you. You wouldn't know, for instance, to differentiate between a ground of law and a ground of fact, or mixed law and fact. You may not, but you most likely will not also know the difference between filing, the time within which you are to file an interlocutory appeal or a substantive appeal. And then there are a lot of, because appellate processes, appellate proceedings in Nigeria, and I believe elsewhere, are highly technical. So it will take time. Before you take time to achieve excellence, you would have committed some blunders that will have a serious blight on the justice delivery system. So that is the only reason why I'm saying that people in the academia may not or should not be considered seriously as people who are in practice. So the advantages are there. And then when somebody is also changing environment, for instance, you are appointing someone from outside to go to the bench, the zeal to excel will be more than when he sees it as a right, as I'm here as the next most senior person. And then he will also be approaching it as somebody who is coming newly, seeking to impress, seeking to try to put in his best in terms of justice delivery. So the advantages are there, and we have always argued that for us to have the best, we should mix private legal practitioners who have excelled, who have at least shown themselves to be good practitioners, because everybody we know ourselves. And then because the process will be rigorous, the testing process will be rigorous. It could even involve voting at the level of body of senior advocates and the Nigerian Bar Association. And then the judges will also have an input. So with this, we will have a good blend and a good appellate system in place.
Thank you, Chief Sebastine Hon. That was a very interesting point of view. Even though I'm not sure Dr. Yakubu will agree with you that there's a disadvantage of appointing members from the academia. But anyway, we appreciate those contributions. Now, Dr. Yakubu, over to you. The campuses of the Nigerian Law School are facing a collapsing of infrastructure due to insufficient funding and ever-growing number of candidates. As a result, there have been calls to allow for the establishment of private law schools side by side with the Nigerian Law School, with a strengthened Council of Legal Education to set the examination for all aspiring members to the bar. Do you think the establishment of private law schools can improve the standard of legal education in Nigeria?
Thank you, Kendi. I would like to engage Honorable Sebastine Hon, but not here in private, on a discussion, not on a confrontational basis. on the need or on the merit of appointing academicians into the bench. But coming back to your question, actually, I think it is right, because I'm talking from experience. It is right now to allow private law schools. Why I say this is because of the number of students that are graduating every year from faculties of law in each and every, in almost all the universities. And I can tell you that law, like myself, who is in a private university teaching, law actually is the most popular courses at Nile University. We have limited quota, but you get internal transfers from other faculties, because those who are not able to get admission to read law straight from 100 level, they will get admission to read into political science department, sociology, criminology, with the intention that after the first session, they transfer to the faculty of law. As I'm talking to you now, we have a backlog of students. Like last year, due to coronavirus, the law school was shut down for a complete year. But we at Nile, University of Nigeria, we continue teaching thanks to technology, like I highlighted in my opening remark. So we did not, after the first 2 weeks of confusion, we got a balance and started teaching using Teams, using Zoom, and other means. So because of that, we had two sets who were not able, who had to be combined together to send to law school. And by the time we were sending them to law school, we could only send 50 of them out of 100 plus. So you can see, and there are many other students who, especially in the public institutions, who are there waiting for the law school. Despite the fact that now that the government has approved more law schools, plus the one built by the River State government, thanks to the governor of River State, still the spaces, the space in law school is not enough to accommodate all the students who have graduated. So based on this, I think it is very important for the government to consider. It will really, really help in absorbing the teeming number of law graduates who cannot get at the moment admission into law school because of because there's no facility to absorb them. If we look at the United States, United Kingdom, for example, law schools are even mostly private. I don't know any public law school in the United Kingdom. And the standard is not falling. In fact, the standard is one of the best standards. The standard of legal education in the United Kingdom is one of the best standards all over the world, because students come from Canada, from the United States, from New Zealand, from everywhere to come to the United Kingdom to study. So with proper regulation from the Council of Legal Education, and especially with the suggestion that the Council of Legal Education should be the one that will be setting examination questions, just like WAEC and NEPO is doing. I think we will still have a very high standard of legal training and education in Nigeria, even with the private law schools. And in fact, at the moment, there are already tutors at the campuses of the Nigerian Law School, private tutors, who are actually tutoring law students on how to pass the finals. And their success rate is almost 90%. So you see, this is already, there's already a litmus test, I can say, because some private individuals have constituted themselves either jointly or severally conducting tutorials, assisting the law school students to write and pass the above finals. Thank you.
Thank you, Dr. Yakubu. This next question is for Mr. Afam Osigwe, Senior Advocate of Nigeria. Now, Mr. Afam, continuing legal education is central to the development of a vibrant bar. However, many lawyers complain about the high costs of very good CLE programs. What incentive should be created and by whom to ensure that lawyers are able to access reasonably priced continuing legal education programs as they progress through their legal careers?
I think one of the incentives which we have at the moment is the MBA-driven continuing legal education, powered by the Institute of Continuing Legal Education, and also which you also have in the branches. Some of the continuing legal education programs are pricey, no doubt, but some that are also not so pricey as productive as those that are pricey. And it stands to reason too that if most of our lawyers do well in their private practice or in whatever organization they work, maybe, just maybe, they may be able to afford some of these things. But I think as part of his duty, which is the improvement of lawyers, and then law reforms and all that, and the MBA should do well to channel some of the money it gets from payment of practice fee to providing continuing legal education programs free of any charge to our members who may not be able to afford the expensive ones. Those who work in organizations that may be able to afford them or who can personally afford them may continue to go on with the ones they want. What is important is making continuing legal education taken much more seriously. If you look at the rules of professional conduct, it has provisions for minimum number of units every lawyer must, of legal education every lawyer must obtain in a year. Now, this provision of the rule has not quite been adhered to. Now, certificates are issued. We've not made it part of our licensing procedure that if you're unable to meet this minimum continuing professional development points in a year, your license will not be renewed. Until make it implement the mandatory continuing professional development as contained in our rules of professional conduct, lawyers will still complain. It is natural for human beings to complain, especially here in Nigeria, about price of anything. For example, annual practice fee has remained at 4,000 for over a decade, and lawyers still complain that it's expensive, even though compared to the dollar, it's much less. And those lawyers will also have money to spend on some other things that may not improve their ability to practice their profession. Or once it comes to making official payment or to self-improvement things, people would suddenly notice that the price is high. But bottom line is that institutions can provide some of these services and they can be better organized, and then the body should be licensed to provide them. And then if there's enough competition, maybe, just maybe, it will be able to drive down the price and make it much more affordable. But until then, MBA should continue to do the work is doing in providing continuing legal education free of any charge to lawyers, so that many more lawyers will be able to at least participate in them and improve themselves.
Just staying on the issue of continuing legal education, you talked about the fact that continuing legal education is contained in our rules of professional conduct. However, it has not been implemented as mandatory. Do you think it is time to make continuing legal education mandatory for lawyers in Nigeria?
It is, by law, it is already mandatory. That was what I said. We are not ensuring that there are consequences for those who fail to embark on continuing professional development and gain those points required by the rules annually. Because any lawyer can simply refuse to go for those training and continue to practice from day to day. Some have never improved themselves beyond their days in the Nigerian University Faculty of Law or Nigerian Law School. They just keep practicing. They do not know about emerging areas of law. They do not know about changing legislations and all that. They just continue to practice. There's no effort made to develop themselves professionally. So that's why I said, if we should tie this to renewal of our practice license, and I believe they proposed the bill on the amendment bill on the Legal Practitioners Act will be able to drive this because it has provision for licensing of a law office, renewal of license of practitioners. And this issue will be taken seriously because the legal profession should be able to showcase its best, should be able to showcase those, should be able to license to practice rather those who will be able to provide quality service to clients, who will be able to give top-notch advice to those who require advice from them, and so that the legal profession will be seen as those that, a legal practitioner will be seen as persons who are really prepared for the job. And it is only continued professional development or continued legal education that can do this. But when you have ill-prepared lawyers or lawyers whose knowledge is at best obsolete or many years behind, then it will leave with a large segment of people who give, we will have a large segment of society that are dissatisfied with the quality of legal services they are getting. So I think it should be made, it should indeed sorry, a call keeps interrupting me.
All right, thank you, Mr. Osigwe, for your contributions. Now, moving over to you, Chioma. There has been a lot of public discussions on the inadequacy of the salaries of judicial officers. Chief Sebastine Hon just spoke about the case which he handled and the decision which was passed down. Do you think there has been a marginalization of non-judicial officers who are critical operators of the infrastructure of the justice system? Do you think that they should be included in the conversation as to increments of salaries?
Okay, thank you very much for that question. My straight away, my answer will be a yes, and an emphatic one. And I say that because just as the recruitment and the training of judicial and non-judicial officers are handled by the National Judicial Council, it goes to say that there is a realization that the effectiveness of the two trained components within the judiciary is critical to effective delivery of justice. If it were just about the judicial officers having worthwhile remuneration, then maybe we'll be losing sight of the role of the non-judicial staff in the dispensation of justice. Oftentimes, the court users, the litigants and the rest of the people, the rest of the public who come in contact with the court, come in contact with the non-judicial staff at the first instance. And it is only after things develop to the point of hearing and the rest of it that they now transcend to meeting with the judicial officers. And since they are the people who interface mostly with the public, it is important that their commitment to duty, their sense of dedication to their job is encouraged. And there is no way that can be optimally encouraged if we do not take into cognizance the role of proper remuneration as a means of encouragement and as a means of motivating performance and output. Most of the things we hear about how the judiciary is corrupt and what have you do not stem from the activities of our judges and our justices and even our magistrates. They are mostly stemming from the impression of the public from interacting with non-judicial officers. You see things like maybe extortion from the public, maybe because we do not have a coordinated way of documenting and even appraising costs in service delivery. So oftentimes you see many of them extort people even for little things like service of processes and then compilation of records of proceedings and all of those other things. So it is critical that we pay attention to see that our non-judicial officers are well remunerated, particularly in a country such as ours, where inflation keeps rising by the day. If we look at the cost of living now, it will be almost ridiculous to expect that some of the advised rates, like for example, for service of processes, maybe to designated locations and distances can continue. There is no way that will continue. So you see that many times, many of them look for ways to make ends meet. There was that disclosure by the Chief Justice of Bauchi State recently, who complained, she raised the alarm that non-judicial staff within the Bauchi State Judiciary were getting engaged in corrupt practices, and to the tune of, I think, about 11.5 billion naira or something of the sort, forging forms, forging letterheads, forging all sorts of things to circumvent the process and the institution, and then make monies from the side. So we need to deliberately refocus, not just, it's most commendable, the action taken by the learned senior advocate of Nigeria, Sebastine Hon, in ensuring that the fate of our judicial officers are better served. But that needs to extend to the non-judicial officers, because really their roles are critical. If you remember, just very recently, they caused a paralysis, as it were, of the justice system for over 2 months by the strikes they embarked on in 2021. And that tells you the enormity of the powers they hold. Whether we want to recognize it as such or not, this is a people who can determine whether or not the rest of the system works. And if we realize that, then we must deliberately pay attention to ensure that their needs are met and that they are given optimum support to deliver the roles they are assigned to deliver.
Thank you, Chioma. Quickly, because we're running out of time, I'll just ask one more question for Chief Hon. So are you there?
Yeah, I'm here.
Okay, so quickly, in 5 minutes, sir. Federal judges are appointed by a quota system called the federal character, so that all regions are represented at the federal level. In your opinion, do you think the observance of the quota system in the recruitment of judicial officers affects the overall judges based solely on merit, or should the current quota system continue to be factored in such decisions?
I will support wholeheartedly the quota system, that it should continue. Now, gone are the days when maybe one particular region in Nigeria held the S. We have a situation whereby all regions of Nigeria now, as far as the legal profession is concerned, have very competent people, either on the bench or at the bar, to fill in these quotas. So Nigeria is a multi-dimensional country, multi-ethnic, multicultural. So there's no way we can do away with the quota system. The Court of Appeal and the Supreme Court of Nigeria also deal with issues of Sharia law and customary law. And then we have a good number of people in northern Nigeria who are experts in Sharia law, and a good number of them are also experts in customary law. Now, if we say that appointments to the Supreme Court and the Court of Appeal should be limited to particular zones, those two aspects of the law will suffer. And I also say that quota system is established in the Constitution. Except if we are going to restructure fundamentally and do away with quota system in all aspects of our life, the issue of maintaining quota system in the judiciary remains sacrosanct. It should be there. And now look at a situation whereby we're talking of regions, geographical spread. We're not talking of state by state. We have 6 geopolitical zones in Nigeria. So if, for instance, in the north central zone that I come from, somebody from Benue State, which is my state, is not as good, you can go to Nasarawa State or Kogi or Kwara State and pick somebody from there whom you think is good. The same thing happens if you go to the northeast or the northwest or to the southwest or southeast or south-south. So we don't have, in Nigeria now, we have good legal practitioners in all the zones. We have good judicial officers in all the zones. We have good academia in all the zones. So there's no way anybody will begin to tell me that we should abolish quota system and then go for the best. Where are the best? The best are in all the zones. So, and they will keep coming because everybody is involved. Everybody wants to excel. Now, let me give you an example. I'm a member of the Legal Practitioners Privileges Committee, the body that appoints and disciplines senior advocates of Nigeria. Now, we just finished one inspection of law firms. And this is my 4th year, my 2nd term, which will expire this year. In all of my 4 years, people of all zones have excelled because we do chambers inspection. There was a time I traveled to Kano, I traveled to KB, what I saw, I was pleasantly surprised. And then we also conduct interviews of applicants. Come and see how people from all zones are excelling. And then some people from the zones who think you excel, some of them may not be as good. And again, quota system is not just the criteria. If you look at Rule 3 of the NJC Procedural Rules for Appointment of Judges, Rule 3.6, Paragraph 6.4, they said, in carrying out the provisional shortlisting exercise, the chairman of the Judicial Service Commission or committee shall take into consideration as much as possible. Then they started listing. If you go up to 4, federal character or geographical spread, and where necessary and possible, without compromising the independence of the judiciary or allowing politics to permeate or influence the appointment. So there's a balancing provision. It's not just that you just go there and pick anybody. You have to balance it, and even in the balancing, you do another balancing to make sure that politics and improper appointments are not appointees are not put into our judicial on our judicial benches. So I go for quota system any day, any time. Now, if you do a comparative analysis, a lot of such criticisms, I have with me here the NJC rules. They are more comprehensive than what we even have in the UK. And for God's sake, go to America. It is even based on politics. When they want to appoint justices to the Supreme Court, they talk of the Democrats and the Republicans openly. And he's there, even within the states. So, but here we have standard rules that are guiding us. And we're still, those things, quota system, rather than divide us, brings us together. Because everybody has a sense of belonging. And in every zone, and I dare say, in almost all the states, we have competent hands. And they have been delivering. Me, I'm a researcher. I write books, as maybe most of the practitioners here will know. And I quote judges in extenso. I quote their findings. I quote their judgments. There's no limit to knowledge. There's no limit to knowledge based on ethnicity or geographical location. I can assure you of that. We have had fine justices on the Court of Appeal bench, on the Supreme Court bench, even as we speak. I don't want to mention names because these records, they are still sitting. If they were not still sitting, I would have mentioned people like Mahmoud Muhammad, the former Chief Justice of Nigeria, who is from Taraba. Very, very articulate justice of the Supreme Court. He ended up as the Chief Justice, and then Kassina Alu. These are people from the north, And then we don't want to mention people from the advantaged geopolitical zones. They're already good. But we have also had good ones before, and we will continue to have, even now we have. So quota system brings us together, encourages everybody, and it binds us, it builds the federation. This is not a loose federation. It's a watertight federation. Thank you.
Thank you, sir. Unfortunately, we've run out of time, so we have to bring this session to an end. I would like to thank all the panelists for their time and insightful contributions. I would also like to thank our audience for tuning in and joining us. At this point, I will be handing over to Professor Uche for his closing remarks. Thank you, everyone.
Thank you. Thank you very much to all our panelists for a very robust discussion. Thank you, my good friend Kayinde, for facilitating such an insightful discussion. And a tremendous thanks to everyone else who has attended this panel discussion for being a part of our webinar today. We're grateful that you joined us from different time zones to share your wealth of knowledge and expertise with our audience. I would like to also thank the team at the Lincoln Alexander School of Law that has made this possible in terms of the technical support. If you enjoyed today's webinar, please check out our website at the Lincoln Alexander School of Law and follow us on Twitter for news and updates about future events. Thank you for joining us, and we hope to see you again very soon. Thank you.
Thank you. Bye-bye.
Oh, bye-bye. Thank you.
Thank you very much.
Thank you.